All right, good morning, Whitmer High School government students that have Mr. Schreiner. We're going to look at our notes today through YouTube, and I'm going to go through a few of these things on the judiciary, so you can just follow along and also work on that um, assignment that goes along with this here. All right, the judicial branch, to kind of go through a couple things, we're talking about the Supreme Court and all of the other U.S. district courts. Article 1 of the Constitution discusses the legislative branch. Article 2 discusses the executive branch. And then the judicial branch, as you can see here, is created through Article 3 of the Constitution. All right. Within this article, they talk about the judiciary and what it's going to kind of look like and what powers, or what we would say jurisdiction, areas where this national court can hear cases. The Constitution created a Supreme Court, and that's what it's called, is the Supreme Court, and it gave Congress the power to create inferior courts as needed. Now, what we're talking about inferior courts is the founding fathers knew that one Supreme Court, one national court, could not handle all the business. It couldn't handle it in the 1780s. It wouldn't be able to handle it in the future. The founding fathers knew that the nation would grow. So rather than putting in a specific number of courts, we have a little bit of a separation of power here. And one of the checks and balances that Congress will create courts throughout the country as it needs. And we'll refer to these as inferior to the one superior court or Supreme Court. All right. And in 1789, Congress passed what they called the Judiciary Act, and it created most of the system that we actually have today. Every single state has a U.S. district court. There are court of appeals. There are courts that handle just crimes on the seas. They have courts that deal with patents. So as Congress has needed, or as the judicial branch has needed courts, Congress has been there to create the courts and create the seats. The president will actually put the people into those positions. So we'll talk about that in a little bit. Let's start with the Supreme Court of the United States. The Constitution is silent on how big the court should be, leaving that up to Congress. So currently, Congress has established the Supreme Court, and it's been like this for about 130 years, as 9 members. They're all co-equals, but they do have what they would refer to as the Chief Justice, who is kind of the head of the court, is kind of the first to speak, sets up the agenda and everything like that. And then there are 8 associate justices for a total of 9. Now, Alexander Hamilton referred to the Supreme Court and the American federal judiciary as the least dangerous branch. Their job, in his mind, would be to review the acts and laws and actions of the other branches to determine if they would have that power. But they would be kind of outside of policymaking. And a couple things that are unique to the Supreme Court. The first one, you can see right here, it says lifetime appointments to office. Unlike the President of the United States, who has to run every 4 years and actually has term limits, or a congressman in the House who only has 2 years, or a senator who has 6, the position of the Supreme Court justice is a lifetime position. They are only removed by death, retirement, or in some rare cases, they could be removed through the impeachment process. None of our members of the Supreme Court have ever been removed through the impeachment process, but we have obviously had death and retirements. Over the years, people have discussed this lifetime appointment. What was the purpose? Why did they have it? Well, we have to look historically. If we go back into the colonial times, King George III often influenced the judges to rule against colonists. He would withhold their salaries. He would remove them from position. There were lots of different things that the king had power to influence judges. Say, well, we'll pay you in 3 years for the work you're doing now. A lot of influence. We wanted to make sure in our system that we would have a truly independent judiciary. Lifetime appointments, they don't have to worry about making anyone happy. Once they've been given the job, they are free to make decisions as they see fit. No one's going to take their salary, no one's going to take their job. They really, for the most part, can't be removed. This was to remove them from all political pressures. King George's, violations to this, the independence of a judiciary, were even mentioned in the Declaration of Independence. So we thought very long and hard how important it was to have these courts that were truly independent. This picture here, if you look, are the current 9 justices in what we call the Roberts Court. And Chief Justice John Roberts, who's 65 years old, these are their ages here, who's 65 years old, has been seated since about 2006. He worked in the federal court system and became Chief Justice when President George W. Bush appointed him became Chief Justice when George W. Bush appointed him to that position. It was open due to the fact that there was a death in that role. Seated here, kind of in order, Clarence Thomas, George H.W. Bush appointed him in early 1990. So he's been on the court for close to 30 years. After that, kind of in a seniority here, is Ruth Bader Ginsburg, 87, the oldest on the court. She's been on the court since Bill Clinton nominated her to that position. Bill Clinton also nominated Stephen Breyer, who is 82 as well. After that, the Chief Justice was put on by George W. Bush. We mentioned him. George W. Bush also put on Samuel Alito, 70 years old, around 2007, 2008, onto the court. Then President Obama had Justice Sonia Sotomayor here, who represents the first Hispanic on the court, and Justice Elena Kagan, put on sometime I believe in President Obama's first term. President Trump has had the opportunity to put 2 justices on. His first was Neil Gorsuch, which was an opening that actually occurred during the Obama administration, but the Senate Republicans refused to hear any of Obama's appointees. And then he also put on Brett Kavanaugh, which was last year. And you can see the ages are 53 and 55. So our oldest, Ruth Bader Ginsburg, 87, being on the court for just under 30 years, and Clarence Thomas approaching that 30-year mark. You can kind of see the age disparity from kind of our seated justices with more tenure and seniority to our more new justices here. This back row here, these 4, in the next probably decade or so, will be seated along here. And some of our old-time justices will eventually retire or pass away. So when a vacancy occurs, the president, this is one of the great things that the president gets to do, because their presidency will end 4 years, 8 years, and one of the very few things that get to carry on are the members of the Supreme Court. And they really want to have the president's influence to go further on in the future, and appointing a justice that the president feels will kind of carry his legacy is very important. So they will go through tons and tons and tons of different nominees and finally come up with a name of someone they think they can get through the political climate. When they give that appointment name, the United States Senate will conduct a series of hearings asking all types of questions to the nominee. And this is several hours over several days, talking about past rulings, jobs that they've had, any past statements that they've had or concerns that the senators may have, anything going back from their law days to their college days. Lots of different things kind of come out. And hopefully the nominee is prepared for all of the questions that senators will have for them. Some of the senators like this person and are kind of with the president, and then of the opposite party, they may challenge this a little bit. And what will eventually happen is the Senate will vote to confirm or reject the nomination. If the Senate passes by simple majority the nomination, then the justice will take their seat on the court or on the bench and have that lifetime appointment. In the rare case, the Senate can reject the nomination. And if that happens, then the president has to start the process back over again. And probably a little embarrassed because he did not get his nominee through. The most recent case was a little over 30 years ago. President Reagan put a name forward, and the Senate rejected and blocked that nomination. The Samuel Alito character, if we go back a little bit, he was actually President Bush's second choice. His first choice was really wasn't blocked by the Senate, but both Senate Republicans and Democrats showed some resistance to President Bush's first choice, to the point that the president's own party, the Republican Party, said, maybe you should come up with someone else. And the appointment was taken away, and a new nomination with Samuel Alito was given. All right. So let's talk about some of the hearings and cases. All right. Cases are appealed through the lower courts, and eventually the Supreme Court will have to decide on whether a case is worthy of hearing the court. Now, we're not talking about traffic cases or even murder cases. We're talking about cases that challenge a constitutional principle or seek to clarify a law, throw out a law or presidential action. A lot of times they're First Amendment cases or rights of the accused, and they're asking bigger questions than just, is this person guilty or not? Okay. When the Supreme Court, or if the Supreme Court decides to hear the case will go in front of the court with all the documents from all the years, starting from let's say if it was a criminal question, from the arrest, moving all the way forward, as well as any documents that other legal experts may have. And then the court has those things, and then the court will actually have what they call the oral arguments. And it's a timed argument where each of the two sides get to address the court with their ideas, their thoughts, their concerns, and the justices are allowed to ask questions, and they virtually just interrupt them with whatever question they have. If for some reason the court decides not to hear a case, the Supreme Court says, nope, we don't need to hear this. They kind of have something called the rule of four. If 4 of the 9 justices want to hear the case, then they'll hear the case. And if they can't get those 4 justices to say, yep, we think the Supreme Court should hear this case, then the lower court, whatever their ruling was, will stand. So they're kind of making a decision by allowing the previous decision to be the standing. After the justices hear the oral arguments, they will go into a debate process. And this can take several days, weeks, and even months, because they're hearing lots of cases around the time. And they will debate and discuss amongst themselves. We don't get to see any of this. And then they will vote, basically, who is the winner, all right? And the majority will write an opinion. And this really defines the decision, whether one side was right, one side was wrong, clarifies any things in the law, can make suggestions, can throw things back to Congress and saying, we're not going to discuss this, but Congress would need to make that decision. That's the majority. Those that are not with the majority often write their own opinion of why they disagree. And we refer to this as the dissenting opinion. If you are reading any court cases from the Supreme Court, most people think, you just read the majority opinion because that's the most important one. It is, but you should also read why there was dissent. And not in all cases, but in some cases, they often can have something called the concurring opinion. And the concurring opinion is basically it's an opinion usually of the majority. They believe whatever the majority has decided, but they often have different reasons. So they will seek to kind of clarify why they agree a certain party was the winner and kind of their reasons why. So all of these opinions are very, very important to read. Why they were for it, why they were against it, why they were for it for different reasons. All right. We're going to look at one particular case today, the case of Marbury versus Madison. The real reality, folks, is the Marbury versus Madison case. You don't really need to know what it was about, but this was a situation where the Supreme Court had to really challenge, or was challenged, to have this power of what they call judicial review. And judicial review is this constitutional principle that the national judiciary, including the Supreme Court, has the jurisdiction to determine the constitutionality of laws and actions by different branches of the government, as well as over the states in certain cases. And the case, it's kind of an odd thing, but think of it like this. The Supreme Court had to hear a case to determine if they had the power to determine constitutionality. Now, that may seem odd, but there was no other court to determine the Supreme Court's power, so they had to hear the case. And of course, they determined that they did have the power. And I've often thought about it and thinking, if you're asking them, you must automatically believe that they have the power. Otherwise, why would you be asking them anyway? All right. And I know this gets a little confusing, but ultimately, the power of judicial review in the Marbury versus Madison case is what you need to walk away with. The court established its supremacy. The court established that the Constitution, even though it may not have been exactly clear on judicial review, they believed, the court, that it was. The court can determine if Congress, if states, if the president have conducted actions or laws that are against what the Constitution and the rights of the people are. This is the power of judicial review. All right, how do we view the court's role? Well, there's kind of two trains of thought here. And if you look at this slide, it says judicial activism and judicial restraint. Now, I'll just read the definition. Judicial activism is a legal term that refers to court rulings that are partially or fully based on a judge's political or personal considerations rather than existing laws. Some people believe that the role of the court is to look at current conditions, and judges often will bring in their personal beliefs into making a decision, rather than specifically what does the law say, almost where should the country be. This is what we call judicial activism. Now, others believe in what we would call judicial restraint, which in this case encourage judges to limit the exercise of their own power. It asserts that judges should hesitate to strike down laws unless they are obviously unconstitutional. And of course, what's unconstitutional and what's constitutional is a matter of opinion. But this restraint says, okay, as a judge, I might believe this. As a person, I might believe this. As a political figure, I believe this. But unfortunately, the law or the Constitution does or doesn't say something. So even though I believe as a person we should do this, as a judge, we're going to go this way because that's what the law says. That's what the Constitution means. Ultimately, another way to look at the difference between judicial activism and restraint is similar to this. Is the Constitution a living document? Is the Constitution something that, as written in the 18th century, we should follow the advice and the exact wording, or does it allow for growth? And one example that used to come up is the idea of execution, or what we'd call capital punishment. A lot of people believe that execution, the government executing people, is unconstitutional. But if you go back to some of the people that are what we'd call a strict constructionist, they would say in the 18th century, execution was a legal punishment. So if the Constitution, if the Founding Fathers wanted to ban it, if they believed that it was unconstitutional for the government to execute a criminal, then they would have done it then, but they didn't. So to go back or to go forward 200 years and say, well, it's unconstitutional, the founding fathers didn't mean that. Well, it was a standard crime at the time. There are examples in the Constitution of things that the founding fathers didn't want this new country to do, and that wasn't one of them. All right. I got a couple pictures here as we move on because I want to kind of keep this short. This is the Supreme Court courtroom. You can see along the back here where the justices sit, Chief Justice in the middle, all right, and then they kind of go by the seated judges from the picture earlier are closer to the middle, and then the the least senior, or the most recently added to the court, they kind of sit towards the end. All right, and the hearing group will sit about here. People can also sit here that are kind of within, and then they have viewing areas. No cameras, video cameras are allowed in the United States Supreme Court. So they have audio recordings that are done. They have court reporters. They have, if you've ever seen some of those sketches done, but they do not allow any video recording. And then the outside of the Supreme Court is kind of looks a little blurry actually. But a beautiful picture of the Supreme Court building from the outside in Washington, D.C. So if you ever make it to D.C., make sure you get a chance to visit this. And if the building's open, they'll actually let you into the courtroom. All right. So this has been the National Judiciary, or the Supreme Court. This assignment or these notes go along with, I think, 7 or 8 questions. So you can rewatch this, go through, answer those questions. If you have further questions, just email me and we can get those answered. All right, I'll see you guys later.